Hello and welcome to AM Guide Assam. In this video, I am going to discuss 5 important topics of jurisprudence. The first one is legal personality of a foetus. So first of all, what do you mean by foetus? Foetus means an unborn child. Okay, a child that is in the womb of her mother, that is not born yet. So what is the legal personality of a foetus? That is, how does law consider a person who is not born yet? Okay, so let's begin with that. So this topic is generally you have to study for 2 marks. Okay, so let's begin. The legal personality of a foetus refers to the recognition of a foetus, that is an unborn child, as a legal subject capable of having rights and duties. So first of all, you have to understand that the legal personality of a fetus refers to the recognition of an unborn child who is not born yet. So it recognizes them as a legal subject or legal person capable of having certain rights and duties. So any legal person has certain rights and duties. So legal personality, it refers to the rights and duties of an unborn child. Okay. This concept varies significantly across legal systems and is influenced by cultural, religious, and ethical considerations. So, in general, if you see, a fetus or an unborn child is not considered a legal person until it is born alive. However, certain exceptions exist where the law grants certain rights to the unborn child. So, if you're writing for 2 marks, this one is efficient for 1 mark. Now you have to add something more to get one more mark. Okay, so under the Indian law, what does the Indian law recognize about foetus? So under the Indian law, the status of a foetus is not explicitly defined, but certain provisions indicate limited recognition. Okay, so you have to give 2 or 3 examples now. For instance, under the Hindu Succession Act, an unborn child has inheritance rights if it is subsequently born alive. Okay, the Hindu Succession Act, it recognizes a fetus or an unborn child that he has certain inheritance rights if it is subsequently born alive, or if it is born died or dead, then it does not have any right. Okay, similarly, if you see section 316 of the Indian Penal Code, that is IPC, now it has become BNS. So section 316 IPC criminalizes causing the death of a quick unborn child. The Medical Termination of Pregnancy Act as well, it allows abortion under specific circumstances, balancing the mother's rights and the fetus's personal life. So if you write 3 or 4 sentences regarding this topic, then give these 3 examples, and it is enough for 2 marks. Okay, so topic 1 is done. Let's begin with another topic now. Legislation. What do you mean by legislation? Okay, so legislation basically means law, any law or any statute that is created by the Indian constitution or parliament. Okay, so you have to write it for 2 marks. Sometimes it comes for short notes of 4 or 6 marks. Okay, so legislation refers to the process of enacting laws by a competent authority, usually a legislature. Okay, legislation means the process of making law by a competent authority, that is usually a legislature. It is one of the primary sources of law and serves as the foundation for the governance of society. It is the primary source of law. Then legislation is categorized into 2 types, that is primary and subordinate legislation. Now, what is primary legislation? Primary legislation is enacted by the legislature, while subordinate legislation such as rules, regulations, and orders is made by authorities empowered by the legislature. So, first of all, primary legislations, they will be made by the parliament itself. Then subordinate legislations will be made by the state level or block level or any other subordinate body which is empowered by the legislature or the parliament. Okay, now In India, if you see, you have to refer the Indian context as well. So in India, the legislative process involves multiple stages. What are the stages? Number one, a bill which is a draft of a proposed law is introduced in either the Lok Sabha or the Rajya Sabha. So first of all, a bill should be introduced, then it undergoes readings, debates, and scrutiny by committees before being passed by both houses of the parliament. Some debates are done. Then, once approved by the president or the assent of the president is got, the bill becomes an act. Okay. Now, what is the role of legislation? Legislation plays a crucial role in addressing social, economic, and political issues. For instance, you have to give one example as well. Laws like the Right to Education Act and the Consumer Protection Act have significantly impacted societal welfare. Okay, so for 2 marks, this one is sufficient. Then, the most important topic number 3, grand norm. What do you mean by grand norm? Okay, so the term grand norm, it was introduced by Hans Kelsen, a prominent legal philosopher, as part of his pure theory of law. That is, the concept of grand norm is found in pure theory of law propounded by Hans Kelsen. Okay, what does it refer basically? It refers to the foundational or fundamental norm or basic legal order upon which the validity of a legal system is based. What is grand norm? Grand norm refers to the fundamental norm or basic legal order in a society. Okay, then according to Kelsen, the grand norm is the ultimate source of a legal system's authority, and all other norms derive their validity from it. Grand norm, that is ground norm. If you say ground norm, what is a norm? That is ground level norm. Okay, all other norms derive their authority from this grand norm. Next, the grand norm is a hypothetical construct that exists independently of moral or political considerations. It is not enacted by any authority but is presupposed to explain the unity and hierarchy of a legal system. Okay, so you have to give one example as well. For instance, in a constitutional democracy, if you see, the grand norm could be the principle that the constitution is the supreme law of the land. Okay, the grand norm is the basic norm or the basic idea. That is, in a constitutional democracy, if you see, in for example, in India, the constitution is the supreme law or supreme authority. Okay, so all laws, rules, and judicial decisions must conform to this foundational norm. That is, any law that violates the constitution, it is a void law. Okay, this is done. So this will be sufficient for 2 marks. Now, Hans Kelsen and the nature of international law. Topic number 4. Let's begin with that. So Hans Kelsen, a renowned legal theorist, made significant contributions to understanding the nature of international law through his pure theory of law. Kelsen viewed international law as a distinct legal system, independent of national legal systems and governed by its own grand norm. Okay, now we have to write 2 or 3 more sentences. One of Kelsen's key contributions was his critique of the doctrine of sovereignty. He contended that the concept of absolute sovereignty is incompatible with the existence of international law. Instead, he proposed a monist view where international law and national legal systems are integrated, with international law taking precedence. Okay, this one is regarding his natural theory. So, Kelsen's theories have been both influential and controversial. Supporters argue that his emphasis on the legal character of international norms enhances their legitimacy and enforceability. Now, criticism. Critics, however, question the practical applicability of his monist perspective, given the lack of a centralized authority in the international law. So, this one will be sufficient for 2 marks. Now, the last topic is custom. What is a custom? What is a custom in jurisprudence of any law? Okay, so you have to write it for 2, 4, or sometimes for 12 marks. So you have to understand the meaning of this. So custom basically means any rules that exist in a society for a long period of time. Okay, so you have to write custom is one of the oldest sources of law and refers to the practices and norms that have gained legal recognition due to long and consistent usage. Okay, it is particularly significant in traditional and customary legal systems where it forms the basis of societal regulation. So custom basically means any practice that has been any rule that has been practiced in a society for a long period of time. Okay, now for a custom to attain legal validity or essential, it must satisfy certain criteria. Okay, there must be certain criteria which a custom should follow to be considered as a valid custom. That is, it should be ancient. A custom must have been practiced by the people of a locality for a time immemorial, that is for at least 100 years. Then a custom must be continuous, certain, reasonable and recognized by the community, and it should not be in the opposition, or it should not violate any morality or any public law. Okay, so in India custom plays a significant role, particularly in personal laws governing matters like marriage, divorce and inheritance. For instance, or for example, under the Hindu law, customs that are not contrary to statutory provisions can be legally enforced. Okay, so this one will be sufficient from this part, custom. So in this video I've discussed 5 important topics of jurisprudence. So you will get more videos on any topic of jurisprudence or any law subject. So please subscribe to my channel to get regular videos on various topics of law, along with that legal current affairs. So thank you so much for watching the video. Have a great day.